Sorry, Judge, I would like to say that, the BVR is kind of, it conflicts with itself. It says there's a tamper, then it says there's alcohol detected, but alcohol cannot be confirmed because of the way it was tampered with. So I don't know if we have further information to.
We never do. We never do. And the problem is that what happens is people try to put stuff. What is the one thing I ordered you not to do?
Not to drink alcohol, and I haven't. I'm 51 days sober today. And I live in a sober living facility. So I get breathalyzed and drug tested at least 3 to 4 times a week. Anytime that I leave and I come back. I went to an inpatient program and I completed that. I have my certificate right here.
Show me that you have a breath test on 10/26 at 9 in the morning, because if what you're telling me is true, you should have a breath test at around that time. And let's see.
Yeah, I would have to get with the coordinators of the staff at the place that I live in. I'm sure they have it all logged.
You're supposed to have that here today, though. Today is the day that's set for your bond violation hearing.
Well, Judge, we didn't go over all that because I was hoping to get more detailed info. It sounds like there's a tamper, but they're not confirming alcohol. They're not confirming alcohol.
Because of the tamper. What we have normally is someone does something to the device to the integrity of the device to bypass alcohol detection. They could put a sock in between. They could put a piece of paper in between. They could kind of move it so the skin is not touching the device. There could be a whole myriad of things of how the actual tamper takes place. All we know is that we have a tamper and we have a confirmation. Well, we have alcohol detected. We can't confirm.
Right away, you can feel the tension. This is a classic scram device dispute, tamper versus consumption. And here's the key legal issue. The court doesn't need proof beyond a reasonable doubt today. This is a bond violation hearing, which means the burden is much lower. The question isn't, did you drink? It's, did you violate the court's trust? Big difference.
Because of the tamper, the nature of the tamper prevents confirmation of alcohol.
Judge, sometimes these devices, they're not perfect, Judge. They can't ever tell me what happened.
So if there's ever a problem with the device, it is your responsibility to go to the place and get it fixed.
Yes, sir, and I did. Whenever I went to Sentinel, I asked the guy who put it on me and was downloading my data, I asked him to tighten it because I felt as if it was too loose. And he did tighten it, and he said he wrote down on his notes that he tightened it for me. I've been sober for 51 days, and
how do I know that?
I have my certificate that I went to an inpatient program, and I'm living currently in a sober facility. And I'm doing that for myself because I do have an alcohol problem, and I'm 51 days sober as of today.
If you're telling me that you have all that information, that they test you frequently, then you should be able to have testing at that time. And if you can show me that you have a breath test at that time that shows that you're not have alcohol on board, then I'll throw the piece of paper away.
And we do this, Judge. We do allow us to get time to get those documents for you. We weren't prepared to present that to you today. I was looking to get more info on the actual report.
It's supposed to happen today. You guys are supposed to come in between the time we let you know about the violation, to do your diligence, to figure out what the violation is, how it occurred.
This explanation matters more than people realize. Courts treat scram tampering like airport security alarms. You don't get credit for saying, well, I didn't mean to set it off. If the device can't read properly because of interference, judges often assume the worst. Fair or not. Tampering erases the benefit of the doubt.
And how to remedy that?
Judge, that diligence isn't on us, Judge. They're the ones alleging this. They need to provide.
They're not alleging anything. I am, because you have alleged violations here. It is your duty to show us why
We could bring these people that are alleging this tamper, we could bring them and have them testify regarding what they know and what they do not know. Instead of just assuming that they are correct, we could have a hearing.
No one's assuming anything. I'm telling you, If you have something that contradicts this, show it. That's what I'm telling you.
I also did my due diligence of making them tighten it. I told them to tighten it myself.
I understand
And he
that.
did say he wrote a note about that. Because I
I
was
still
afraid
have-
something like this would happen.
Mr. Barahona, I still have alcohol detected, regardless of whether it's tightened or not. The tightening is not the issue. The issue is that there's a tamper and that we have alcohol detected.
I have not consumed any alcohol.
So show me. I'm telling you how to do it. Reach out to them now, see what you can get. See what evidence is out there to show me, I'll put you guys to the side, reach out to them, see what they have. If you're telling me that they've tested you as frequently as they are, they should have something.
Yeah, talk to my client, see how quickly we can get that info.
No rush. No rush. Take your time, see what you can find. Hey, Ricardo,
Judge, you're approaching on Mr. Ramon Barahona.
do you need until Monday?
No, because here's what's going on. So I was kind of unsure about what he was talking about. And after talking to him, we're not going to have a breath result for him because they haven't been testing him, is what it sounds like. And so we got two options, Judge. The way I see it is two options. One, you could revoke them. You could say, well, let me talk about what the specific is on the revocation. Alcohol was detected during tamper. However, alcohol cannot be confirmed as consumption because of nature of tamper. So I would argue, I'm not conceding that something happened. I'm conceding there might be a tamper. I'm not.
Come up, Mr.
conceding
Barahona.
consumption. If you're going to revoke him, I would ask for a full-blown hearing. If this is one of those situations where he's just admonished and, hey, this is your one shot, then he understands that. I don't know how you want to proceed with this, Judge. I'm not conceding that he drank alcohol. He's been in this location, in this center core location since September 17th. He did inpatient. October 18th, he graduated. Then he moved over to Center Court's sober living facility on October 18th. He's been in there since then. We have proof of that. He's been attending 6 meetings per week, 1 counseling session per week, 1 group counseling session per week, 3 AA meetings. He's there. He's doing something. I would ask that we just admonish them.
Machines don't test positive for shites and giggles, man. They don't. There has to be something there to make it test positive.
Well, Judge, on that aspect.
It doesn't spontaneously test positive for alcohol.
Well,
For you to say that it does, it's just disingenuous and not true. There has to be something to set the machine off. It doesn't spontaneously.
This is a pivotal legal moment. Notice how responsibility quietly shifts. The defense is arguing, prove the violation. The judge is saying, prove your compliance. In bond court, that's how it works. If you're accused of violating conditions, silence or missing paperwork hurts you. Fast.
Test positive.
I have not consumed alcohol for 51 days as of today.
The machine is telling me differently, Mr. Barahona. You know how many people tell me the same thing with the exact same facts that you have? You know how many times I hear it a day?
I would assume a lot.
If I had 1 strand of hair every time I heard it, oof, I would look good.
Judge, I did talk to him. This wouldn't be much of a solution since this is from 1026, but we could test him today. I don't know how long something stays in the system, if that's the allegation, but he's willing to test today.
That's going to be no
Right.
bearing on me. I
Right.
mean, this is 2 weeks ago,
I get it.
I'm just now, unfortunately, they just give us the results now, but
And regarding the actual, I've gotten reports before that says what this device is reading. There are reports out there that they can provide.
if they don't tamper, then yes, you will get a true and accurate reading. And that's what the problem is that there is something that was tampered with, and Mr. Barahona knows. He's the only one that knows what happened on that date. We don't, because we weren't there. We don't know what happened. So I'm sorry, Mr. Barahona, but I told you one thing. I told you one thing only, you know?
I would like to state the fact one more time that I did tell the people at Sentinel to tighten it because I didn't want something like this to happen. I don't
This
think
is
it's,
not a matter of tightening. It's a matter of alcohol detection. If a device is loose, it's not going to test positive for alcohol. You understand that?
I
Just,
understand what you're,
there has to be an intervening event that has alcohol in it for it to test positive. And there's something seriously afoot because the device is telling us that someone is messing with the machine. If we not had the messing with the machine, then we would know whether there was true alcohol consumption or not. But here we have a positive and that you're messing with the machine. Okay, goes with you.
This is the judge's credibility wall, and a lot of defendants hit it. When a judge says, "Do you know how many times I hear this?" That's not sarcasm, it's experience talking. Sobriety claims, without contemporaneous testing, don't carry much weight. In court, receipts matter more than sincerity. Hard question for the audience. If everyone says the same thing, who do you believe?
You're Dwayne Leon Leroy.
Yes, sir.
So Leroy, you're charged with 2 cases. You're charged with driving while intoxicated. You're also charged with reckless driving. On the DWI, you're facing up to 6 months in jail and or a $2,000 fine. On your other case, you're facing up to 30 days in jail and or a $500 fine. We're going to do probable cause. You have the right to remain silent. Anything you say can and will be used against you. You have the right to have an attorney present. If you cannot afford one will be appointed to you, sir.
On November 3rd, 2024, officers observed defendant's motor vehicle traveling at a high rate of speed, 105 miles per hour, making unsafe lane changes, cutting off several other vehicles, and driving through narrow 2-lane construction zones and on the Sam Houston Tollway. The officer was able to catch up with the defendant and initiate a traffic stop. Officer made contact with the driver and observed mild odor of alcoholic beverage, red bloodshot eyes, and a slight sway. Officer observed a brown bottle of alcoholic beverage under the passenger seat, open and half empty. SFST is administered, HGN 4 out of 6, walk and turn 4 out of 8, one leg stand 3 out of 4. Defendant denied drinking anything, then claimed to have only consumed 1 beer. DICs were read and breath was refused. Blood search warrant was obtained and executed.
Are you telling me that he's going through a construction zone at 105 miles an hour?
That's what I have here, Judge, per the dams.
Any prior DWIs? Mind checking? Or any kind of other reckless driving?
I don't see anything that has to do with driving on his record.
There's a lot of construction on the Tollway Road. If you're going that fast, probably pass through it,
Like,
rather
you're
quickly.
supposed to slow down at an extreme slow place when you're extremely slow pace when you're going through a construction zone.
I agree.
Mr. Leroy, I'm going to find that there's probable cause to go forward with the case, and I'm now taking away your privilege to drive. You're not allowed to drive at all. Do you understand?
Yes, sir.
You will be signing an affidavit with me, and I hope that you take it seriously, because if not, you will be facing 6 months in jail and a $500 fine every time you drive. And I don't care what your excuse is. Mother Teresa needs a ride to church. You come down, we will have a hearing, and you're facing 6 months in jail and a $500 fine every time you drive. I'm also ordering you not to consume alcohol or illegal drugs, and I'm going to randomly test you. If I find that you're consuming alcohol or any kind of dope, likewise, you will go to jail. You will not get any more PR bonds. Do you understand?
Yes, sir.
These are 2 different affidavits that you're going to be signing. So if I find that you drive, and I don't care what it's for, I will have 2 contempt hearings every time you drive. You have a lawyer. It is your responsibility to stay in touch with Mr. Agel, and he will tell you when you have to come back to court. If he comes back to me and tells me he can't get a hold of you, you pick up a new case. You violate conditions, I will put you in jail. You will not get any more PR bonds. Do you understand?
Yes, sir.
Okay. All right, we'll have you go.
Thanks.
All right, you are Eric Matthew Mack.
Yes, sir.
Mr. Mack, you're charged with criminal trespass. You're facing up to 6 months in jail and or a $2,000 fine. You're also charged with interference to the duties of a public servant. On both of those, you're facing up to 6 months in jail. We're going to do probable cause. You have the right to remain silent. Anything you say can or will be used against you. You have the right to have an attorney present. If you cannot afford one, one will be appointed to you, sir. Okay.
On October 30th, 2024, officers were patrolling an apartment complex in Harris County, Texas, that is known to have a high amount of crime. Officers are familiar with the property manager who has complained about trespassers in the past. There were multiple no trespassing, no loitering signs throughout the apartment complex. Officer observed the defendant walking around the apartment complex wearing a hoodie with the hood up and a mask covering his whole face and holding an unknown object in his pocket. Officer asked if the defendant lived in the complex, and the defendant did not answer. Officers believe that crime was afoot as defendant refused to remove his hands from his pocket. Officers attempted to Terry frisk the defendant for any weapons. The defendant refused to be patted down for weapons. Officers attempted to detain him for a criminal trespass investigation, but he refused to be placed in handcuffs. He resisted to be placed in handcuffs, and it took 4 minutes. It took 4 deputies to detain him as he kept pulling away and moving his hands away from each other. It was determined that the defendant did not reside at the apartment complex.
Mr. Mack, I'm going to find that there's probable cause to go forward with the case. How old are you, sir? What do you do for a living? Why not?
Watch the tonal shift here. We're moving from a technical bond violation into a probable cause hearing, a completely different legal lane. Now, the judge isn't deciding trust. He's deciding whether the state has enough to move forward. Same courtroom, totally different rules. This is where things speed up and consequences stack quickly.
Sorry?
You're retiring?
I can't hear you.
Retiring?
There are so many people that are hiring. It's ridiculous.
Yeah.
Did you graduate from high school?
Yes, sir.
Okay. So what's the next move in your life? You're 21. You ain't got no job. What are you doing with your life?
Military.
That would be a great idea. Holy moly. That would be awesome. Really. That will give you structure. It'll give you discipline, and it'll get you a job. That would be a fantastic thing to do. But jobless, no prospects, no future at 21, that's not going to bode well for you. So I'll appoint your lawyer today, but it's one of the two things. Great idea if you want to go to the military. If not, you must get a job, and I'm making that a condition of your bond. Do you understand?
Yes, sir.
You cannot just smoke weed and play Xbox and do nothing all day without no regard to your future. It's not going to happen. So 2 things. I don't want you going back to this location, and I don't want you to have any weapons. Do you understand?
Yes, sir.
I'll have you fill out an application. I'm going to bring you back in 2 weeks, and I want to see what you have done to get a job. If you've done nothing, it's not going to go well. Do you understand, Mr. Mack?
Yes, sir.
You got to do something with your life, because if not, you're going to be hunchless, just on the side of the road, begging for money without a prospect. That's not a good way to go through life. Do you understand?
Yes, sir.
All right, come on, Stephen, I'll give you an application. You'll sign a reset with Ramona, and then we'll have you take a seat in the jury box. Okay, sorry to keep you waiting. Good morning, sir.
How you doing, Mr. Bishop?
Shh.
So Mr. Peters is wanted out of Caddo Parish on issuing a worthless check. I'm assuming this correlates to like issuing a bad check here in Texas.
Okay.
And so I would be asking for a bond so he could go to Louisiana and take care of this business out there and resolve it.
So he's on felony probation for a false statement obtaining credit, picks up a DWI second, and now he's got this case.
Correct. I've told him what that DWI might do to his probation.
Mr. Fisher, ma'am.
Don't say anything about the DWI because you're on felony probation for a very serious up to 10-year probation. You picked up a new case, and now you have another case in Louisiana. I mean, really.
I had no idea about the case in Louisiana, sir. I had just went to the Army base in Killeen. I was working for Bobtail Crane, and when they escorted us into the military base, nothing popped up about a charge or anything else like that. I had no clue about this. If I would have known about this, I could have easily took care of this. whatsoever.
But the problem is that stuff keeps happening. When do we say when? You know?
Sir, like I said, in the case for the DWI, I was not drunk. I was on my way to work.
Really, now's not the time to fight those cases. My only point is that it just, stuff keeps happening.
Yes, sir.
State's asking for no bond. In addition to the federal probation he's on right now, we're also seeing.
He's on federal probation too?
I'm sorry, I thought you said federal, but the 3-year probation that he was on right now from the 185th out of 2022. He also had a deferred revoked in 2010 from Montgomery County that resulted in 10 months of TDC. He also had another TDC trip for tampering with government record in 2008. He had an evading of a motor vehicle, which is a state jail felony that was reduced to a lesser evading for the 351st in 2007. He's also had a couple theft arrests that resulted in dismissals. He's also on a DWI second here in.
Pen trips you got? 2?
Sir,
Times you been to the pen?
it was just one time, sir. It was just
You're
one
saying
time.
how many times you've been to the penitentiary, Amy?
I'm seeing at least 2 here for TDC.
No,
One in 2008 and another in 2008 from Montgomery.
no. It was only one time.
Here's the thing. If you have 2 pen trips, you're what's labeled a true habitual. Anytime you pick up a serious felony, you're looking at 25 to life. So when you're out there in the free world, you have to be extra special good, because if not, you could be looking at a minimum of 25 years to life.
Yes, sir.
No, I'm just giving you facts.
Judge, if I could argue for my client a little bit, he does have criminal history. The issue here is he's got this DWI, he's made bond on that, he's got a bond there. He is on deferred as well on the 185th. I don't show a court date there. I don't see anything happening there as of yet. The only thing he's here in front of you right now is for issuing a worthless check out of Louisiana. This is something that could easily be taken care of possibly by paying something even from here. If not, he is willing to go to Caddo Parish and avail himself to that parish and figure that out. It's not a serious case, Judge. He does have history. He was, from what he tells me, he was unaware that this popped up. I don't know when this actual case was issued, when it was presented, when it was filed.
Is this a new case? Is this an old case?
It was issued October 31st. The offense date was September 14th.
Of this year, October 31st of this year?
The warrant was issued
I'm
this
sorry,
year.
24?
Yes, the warrant was issued this year. The offense date was September of last year.
October 31st of this year.
They issued the warrant on October of 24. But the actual alleged offense date is
September of last year.
of 23. Okay.
So less than a month, Judge. He's been in Texas.
My problem and my concern are 2 things, though, Mr. Peters. Number 1, are you a danger to the community? Number 2 is you've got a lot of theft cases, and theft cases where other people are involved. So if I set you a bond, is it someone else's money that's going to pay for you to get out? You know, you've got a false statement to obtain credit. You've got a bunch of theft cases. Now you've got another theft case out of Louisiana. So is it someone else's money that's paying for you to get out? And then when we get you out, are you still a danger to the community? You know what I mean? Perception is reality, Mr. Peters, and your record speaks for itself.
Can I say something, Mr. Fisher?
Just don't talk about the
No,
cases.
I'm not talking about the cases. We all have a past. You know what I'm saying, Mr. Fisher? Some of us been called, some of us haven't been called. But at the end of the day, I have changed my life and turned myself around. Since all of those things that you have talked about, I have been driving trucks. I have been doing right by the community. I have custody of my 11-year-old son, that I am being an example of what a man should be. I have done everything that I'm supposed to do, Mr. Fisher. I'm not out here causing chaos and controversy about anything out here in society. I speak at the local church.
DWI 2 days ago, a second DWI, you're on the felony deferred, and now you've got a fugitive case.
Mr. Fisher, that was, again, I was not under the influence. I had just got out for work at Bobtail Crane. That's when that transpired. I told the officer that I did not have anything to do with the drink. He said, because your eyes are red, that does not solidify me as being drunk. I was tired. I just worked 16 hours.
Don't talk about specifics
Yeah,
of the case. It's
okay.
open.
How much is the value of the check?
It was like 511. It's under 1,000.
Judge, he hasn't made a mistake in your court. We're just asking.
But my concern, Ricardo, is where is he gonna get the money to pony it up?
Well, Judge, I know you're speculating that it could be the public's money, but it could also be his money. I mean, he's been working for 5 years. He's got a CDL. He worked at Superstar Logistics for 5 years before working for Bobcat Crane. So he's been gainfully employed. It could easily be his money. I mean, there's nothing to say that it's the public's money or anything like that. He's got a history, but he's got no history with you. And so that being the case, I would ask that he be allowed to make this right. If he messes up at that point, I got nothing to say. But at this point, he hasn't messed up in your court.
Opposed to a bond? What if we set a high bond? You know, I mean, it's gonna be a couple thousand. You know, it's gonna be 5 to 10,000.
I couldn't stop you, Judge, but our position is no bond.
You know, the problem is that you're an inherent flight risk. So if I set you a bond, you're gonna have to pony up all that kind of money to get out. This is no 10% deal. You're a fugitive case, man. So when we set you a bond, you have to post it in its entirety. No 10%, no 20%, just because of everything that you have open, you are an inherent flight risk. So you got to be aware of that. So if I do set you a bond, it's going to be at least, you know, 5,000, 7,500.
There's no way possible that I can, if it's 100% of that bond, there's no way possible that I can do that, man. I'm trying everything in my power. Got a good job and everything else like that. I
See
understand.
this,
But this is just,
not all bad news because you're not wanted out of like Wyoming, Montana, Alaska, Louisiana. We have so many people here from Louisiana. We have buses coming about twice a week to pick up people to take them back and to bring them to from Louisiana. We really have, it's incredible the amount of people we have. So around 2 times a week, we have people shuffling in and out of Louisiana. What I would say is you should save your money and use that to hire a lawyer in Louisiana to fight your case. Because I'm telling you, has he waived yet?
Yes.
You'll be out of here within the next 2 to 3 days if you keep your waive.
Judge, if I may reiterate something, we're at November 7th. I'm still confused whether this was issued the 24th or the 31st. Either way, it's less than, even if it was the 24th, we're talking less than 2 weeks that this warrant has been open. He's got no knowledge of this. All of a sudden, he's being held 14 days in custody with something that just popped up. He's been in Texas working. I don't even know when the last time he was in Louisiana. This has been less than a month that he